How is mental capacity evaluated in a trust challenge? How is mental capacity evaluated in a trust challenge? This is a critical question in the realm of estate planning and elder law. When someone contests a trust, they often argue that the person who created the trust, known as the grantor, lacked mental capacity at the time the trust was formed. This issue is particularly significant in cases involving older adults, where cognitive decline and undue influence may come into play. Mental capacity refers to the grantor's ability to understand the nature and effects of their actions when signing trust documents. The legal standard for mental capacity is generally lower than for other decisions. However, the grantor must still comprehend what they are doing, know who their beneficiaries are, and understand the extent of their property. In evaluating mental capacity during a trust challenge, courts seek evidence that the grantor was unable to make informed decisions at the time the trust was created. Medical records often serve as the most crucial evidence in these cases. These records may include notes from doctors regarding memory loss, dementia, or other conditions that could impair judgment. Medical experts may be called to review these records and provide testimony about the grantor's mental state. Family members and others who interacted with the grantor may also be interviewed. Their observations about forgetfulness, confusion, or changes in behavior can support claims of diminished capacity. However, occasional forgetfulness or minor lapses are usually not sufficient to prove incapacity. Courts typically requiring evidence that the grantor was consistently and significantly impaired, such as being in a coma or showing clear signs of severe dementia. If the grantor was evaluated by a doctor or lawyer and deemed competent at the time the trust was created, it becomes much more challenging to contest the trust on the grounds of mental incapacity. The burden of proof lies with the person challenging the trust, and the standard is quite high. Simply missing a birthday or forgetting small details is not enough to invalidate a trust. In practice, proving a lack of mental capacity is difficult. Courts look for clear, convincing evidence that the grantor did not understand their actions when signing the trust. This process is essential in elder law and estate planning, where the goal is to protect vulnerable individuals from undue influence and ensure their true intentions are honored. To summarize, mental capacity in a trust challenge is evaluated by examining medical records, expert testimony, and witness statements. The focus is on whether the grantor understood the trust and its consequences at the time it was created. This evaluation is central to the ethical considerations in estate planning and elder law, ensuring that the wishes of individuals are respected while safeguarding against potential exploitation.